Good afternoon and welcome everyone to the Tuesday meeting of the House Judiciary Committee. We're today considering one bill that we've had previously 2 days of hearings as far as public input. We closed all further public comments. The bill is now in the breast of the committee, and there will be various amendments to be considered. We want to take the procedure as follows. The chair will entertain a motion as to the bill itself. After the motion on the bill, assuming the motion is a due pass, we will then consider various amendments that have been put together by Ms. Travis, and I've reviewed myself in many cases the amendments. They're just now before the committee members. A lot of the amendments are dealing with, I'll call it, some cleanup provisions and matters that went on with addressing resolution of issues between parties of interest to the bill vis-a-vis the prosecuting attorneys council, the local government authorities, and others who found provisions in the bill that needed to have some special attention. I'm going to ask the assistance of Ms. Travis when we get to that point as far as the amendments as we go through them, because there are 35 of them. Most of them are very brief amendments, but they will take some time maybe to briefly explain what's being done. I will say there's nothing of great context policy-wise changing, except where we're dealing with, say, the issues about the prosecuting attorney's role in the juvenile court. And do we have some people here representing the prosecuting attorney's council? There you are, over there. Thank you. Mr. McDade. Thank you, sir. I want to lead out, if we can, just to the role that we have of the prosecuting attorneys and the amendments. You've seen the amendments? Have you yet? You have not. Okay. Well, we'll be going through it and discussing. I think we've covered everything that was of issue to your office, and if we haven't, as we speak on it, if you want to raise comment about it, please do so. Who is here representing the Association of County Commissioners? Ms. Nesbitt, I see you back in the far area. We have also, I believe, addressed concerns you had addressing the local government side of it, and we have amendments dealing with that. We also have amendments dealing with when a child is to be represented by defense counsel, an attorney, and we've tried to recognize that there will certainly not be a entering of any pleas by a juvenile who's there on delinquency charges unless there has been given an opportunity to that child before entering any plea to have had the opportunity to speak with counsel and then address the court. So those are some of the major policy questions we have, along with some cleanup language. What I'll plan to do, Mr. Jacobs, is we're going to turn it over to you to proceed with the bill and its introduction of the amendments. I will go through amendments, as I mentioned earlier before you arrived. There's 35 of them. I have them outlined in my copy of the bill. I will go through reading the page number and the line number applicable to each of the amendments, and then Ms. Travis and I will seek to address those particular amendments, if that's all right. I'll turn it over to you at this point. There. Your amendments, I believe, are in the folders. You have a package of them, and your first one they're all identified by the bill number, and the first one is AM 292144. So I'll go through. We've stacked them based upon an order of descending order to the page and lines in the bill.
Take a motion on the bill.
That's what we're going to do. Yeah, take a motion on the.
All right. The bill, House Bill 242, the Juvenile Justice Code rewrite, is now in the hands of the subcommittee. The full committee. Of the full committee, and I'll take a motion on the bill to start with.
Mr. Chair.
There is a motion do pass. Is there a second?
Second.
There is a motion do pass that has been seconded. What we're going to do now is take up the amendments in the order they appear in your folders. I'll call on Chairman Willard to explain each one, and then we'll take each amendment under consideration. So, Chairman Willard, we'll begin with AM 292144.
Thank you, Chairman. What I'm going to do is, as you're doing, reading out the amendment number and then the page and reference lines that it will be addressing. This is one that has multiple placements, but it all addresses the issue of what we call the secure facilities, secure residential facilities, non-secure facilities, and non-secure residential facilities. And what we're trying to do is be sure that where we have addressed in the bill how there will be a detention of a child or placement of a child, that we have the appropriate language and type of facility that child will be placed in correctly identified. And so we've had 1, 2, 3, 4, 5 various areas, six areas within the bill, and I will address these beginning on line 310. We have, that's on page 8. I'm sorry, page 9. Excuse me, page 9. We had in here a non-secure residential facilities, which we're striking out that section or that phrase in that particular location. If there's no question on that, I'll move on to the next one, which is beginning on lines 826, 827, and 828, further down in the bill. And here again, page 24, thank you. Again, we have had to correct the term that we have for the secure facility with secure residential facility or non-secure residential facility. That again was just to be sure we had the correct terminology used. The next one we have is on line 922, which will be over 2 more pages, I believe. Page 27, excuse me, page 27, line 922 is replacing non-secure facilities with non-secure residential facilities on that one line, again correcting the term for its use. The next one is on line 4418, which is page 28, 128, thank you. I got my pages okay. On line 4418, we're replacing recommends treatment in a secure environment with recommends inpatient treatment. This is a child who's been already found to be is incompetent to be able to stay in trial. So this is being sure they're put in the right type of facility, and it's recommending inpatient treatment for that child. The next is on line 4454. What page is that, Ms. Travis? 129? All right. Next page over, I think. Here we are. This is line 4454. We are replacing the whole line with just committed to an appropriate treatment setting. And that is to be again, correction of the term, as opposed to a committed to secure treatment facility. Last one is on lines 4536. And that is the secure secure appropriation sanction program means secure confinement, and we're changing that to secure probation sanctions program means confinement in a secure residential facility or non-secure residential facility for 7, 14, and 30, or 30. That's the numbers of persons, and that's again given the court discretion in that area. Chairman, I propose the amendments of 292144 for consideration by the committee.
We'll start by taking a motion on the amendment. Is there a second?
Second.
There's a motion and a second. Any discussion on the amendment? Hearing none, the chair calls the question on the amendment. All those in favor say aye.
Aye.
All those opposed, no. The amendment carries. AM 292106 is next in our folders.
Correct. And we're dealing here with the prosecuting attorneys at line 412, and what you have had in the previous language, we just had then the attorney appointed by the court, so we recognize that the prosecuting attorney means an attorney designated by the district attorney of the judicial circuit in which juvenile proceedings are instituted unless otherwise provided in Section C of Code Section 151861. That is the last bill in this group of amendments, and I'll state for the record what it does, and we'll get to it at the appropriate placement, Mr. Chairman. But that is language that is addressing the fact that there will be either a district attorney designated for prosecuting juvenile matters, or there can be, in counties that have a solicitor general of the state court, there can be a solicitor general with approval of the district attorney to do that process. And if the result is that there cannot be used because of workload and other limitations a district attorney or a solicitor, then there can be someone who is designated by the court. I think it's with the county. I have to read the whole thing to get all of it, but it is to allow someone who can serve, who is an attorney, as a prosecuting attorney for the court. But it has to first go through the local district attorney, if available, and consenting to it. If not, then it goes to the solicitor of the state court, if available, and consenting to it. If not, then it could be an attorney as designated through the county governing authority employed for that purpose as a prosecuting attorney. I think that's the essence of what we're doing. But that's the last amendment, but it is referenced in this provision where we're dealing now with the prosecuting attorney as a definition. And I move for the acceptance of 2106.
Is there a motion on the amendment? There's a motion. Is there a second? There's a motion and a second. Any discussion on the amendment? Seeing none, the chair calls a question on the amendment. All those in favor say aye. Aye. All those opposed, no. The amendment carries. 2107.
And that's at lines on page 19, lines 657 and 658. It starts out reading attendance and testimony of witnesses and production of papers at a hearing under this chapter. And what we're adding is another sentence: a delinquency proceeding conducted in this state shall be considered a criminal prosecution insofar as applicability of Article 4 of Chapter 13 of Title 24. So this is just also recognizing this is if they're there on a delinquency basis, it is a form of criminal proceeding.
Is there a motion on the amendment? Is there a second? There's a motion and a second. Any discussion on the amendment? Seeing none, the chair calls the question on the amendment. All those in favor say aye. Aye. All those opposed, no. The amendment carries. 2108.
This will be on page 20 at line 678. It deals with the issue of mediation. We're adding at the end of line 678 after mediation, but shall not be required to do so as a condition of such case being heard by the juvenile court. In other words, we're encouraging there be an opportunity for mediation, but that is not to stay the responsibility to have the hearing if that is necessary, and there's not to be a form of mediation. Cannot be compelled, in other words. I move for that acceptance of the amendment.
Is there a motion on the amendment? Is there a second? Second. There's a motion and a second on the amendment. Any discussion on the amendment? Seeing none, the chair calls the question. All those in favor say aye. Aye. All those opposed, no. The amendment carries. 2109.
Next one is on line 763 of page 23. This is again addressing the concerns from the local government. The line is putting in county government as well as the state agency, so it read that not as far as expenses and evaluation costs shall not be imposed upon any state agency or county government unless such state agency or county government has funds available for such evaluation. And that is again to address that concern. I move for that acceptance.
Is there a motion on the amendment? Is there a second? There's a motion and a second. Any discussion on the amendment? Seeing none, the chair calls the question on the amendment. All those in favor say aye. All those opposed, no. The amendment carries. 2110.
Next is on page 32, lines 1091, 1092. What we're addressing here is there's a lengthy provision dealing with the disclosure of information certain between agencies involved with a issue addressing the child, and we'd also wanted to be sure, again, at the request of the prosecuting attorneys, it does not take away or remove the right of a subpoena being issued by a appropriate magistrate for a search warrant. And for that reason, we've added D, which says nothing in this code section shall be construed as barring or limiting the release of confidential information referred to in this code section pursuant to a search warrant. We ask to remove that item.
Is there a motion on the amendment? Is there a second? There's a motion and a second. Any discussion on the amendment? Seeing none, the chair calls the question on the amendment. All those in favor say aye. All those opposed, no. The amendment carries. 2111.
Page 114 at lines 3495. This is to give some specificity, Mr. Chairman, as to dates when things are to occur. We want to be sure it's within 30 days of the filing of a complaint with the juvenile court actions to occur, or within 30 days of child's release from temporary custody. So we just really strengthen the language there. Move that acceptance.
Is there a motion on the amendment? Is there a motion on the amendment? Is there a second? There's a motion and a second on the amendment. Any discussion on the amendment? Hearing none, the chair calls the question. All those in favor say aye. All those opposed, no. The amendment carries.
Next,
2112.
It will be at line 3991, and this is a timing when there will be an attorney available, and this is under section F. I'll read. A child alleged to be a child in need of services shall be informed of his or her right to an attorney at or prior to first court, and that is the period should go there, and there would then strike the rest of that provision.
All right. Is there a motion on the amendment? Is there a second? There's a motion and a second on the amendment. Any discussion on the amendment? Here.
I think I made a mistake in what I was saying. Hold on. Go ahead.
Representative Fleming.
Well, Mr. Chairman, I was just trying to figure out the difference in the language from the first mandatory conference, and then the change, I think, is to the first attorney prior to the first court. Is that the change we're making?
Yes, sir.
What's
Instead of at or prior to the first mandatory conference and prior, we're just leaving it as to prior to the first court appearance.
It would continue on there.
Yeah.
Okay.
Right. Okay.
Okay. Thank you, Mr. Chairman.
Any further questions or discussion on the amendment? Hearing none, the chair calls the question on the amendment. All those in favor say aye. All those opposed, no. The amendment carries. 2113.
This will be at the page 119, lines 4107 through 4110. And really what we've done is strike out a phrase on 4109. If you look at the bill, the 4109, where it says adjudication hearing, period, we're striking the rest of that sentence, which is, again, if the court determines that a mandatory conference would be inappropriate or futile. That, again, does not miss, Travis, what you said earlier. And then we add in or number 2. That's where, I'm sorry, that's right. 2 is where we have it, the change, that's only. There is a change in number 1 also, sorry. Refer such child or his or her family for a community-based risk reduction program. That is also a change where we talk about the mandatory conference issue. I move for that acceptance, Mr. Chairman.
Is there a motion on the amendment? Is there a second?
Second.
There's a motion and a second. Any discussion on the amendment? Seeing none, the chair calls the question on the amendment. All those in favor say aye.
Aye.
All those opposed, no. The amendment carries. 2114.
This will be on page 120 at the bottom. Lines 471 and 472 are being replaced with the following provision of the amendment. It says a petition alleging that a child is a child in need of services may be made by any person, including a law enforcement officer who has knowledge of the facts alleged or is informed and believes that such facts are true. Such petition shall not be filed unless the court or a person authorized by the court has determined and endorsed on the petition that the filing of the petition is in the best interest of the public and such child. What we're addressing here is one of the concerns we had with regards to the mandating of the attorney being involved with a petition for filing with the juvenile court. It still recognizes that there has to be court oversight, that not anyone can come in and file such a petition, but we're trying to recognize that a child in need of services is somewhat different from what we may have with a child accused of a delinquent act. But if a child in need of services, we won't be sure people come forward with that information, report it, and could file a petition with the court's understanding and acceptance of it. I think we have a question.
Representative Welch.
Thank you, Mr. Chairman. Chairman, is this in the sense of verification of is there a verification that would be assigned with the petition, or is that just varied in the petition itself?
It doesn't call for verification. It's just setting forth the fact that there is believed to be a child in need of services, okay, and for the court to have that brought to their attention.
So it's an affirmative statement in the petition?
Correct. Okay.
All right, we'll take a motion on the amendment. Is there a second? Any further discussion on the amendment? Seeing none, the chair calls the question on the amendment. All those in favor say aye. Aye. All those opposed, no. The amendment carries. 2115.
It's on the same page at lines 4181 through 4184, and again, this is bringing certainty as to a time for the filing of complaints with the juvenile court intake officer, making sure it's 30 days of the complaint with the juvenile court intake officer, or 30 days such child's released from temporary custody. So it's just to bring certainty in. Ms. Travis? And again, taking out the conference right.
Is there a motion on the amendment?
Second.
Is there a, was there a motion? Yeah, okay, motion and a second. Any discussion on the amendment? Seeing none, the chair calls the question on the amendment. All those in favor say aye. Aye. All those opposed, no. The amendment carries. 2116.
At 4271, 4272 on page 123. Again, taking out the question about the mandatory conference issue that we've had removed several locations. This is the only purpose of that amendment.
There's a motion and a second. There's a motion and a second. Any further discussion on the amendment? Seeing none, the chair calls the question on the amendment. All those in favor say aye. Aye. All those opposed, no. The amendment carries. 2117.
On page 126, Mr. Chairman, at lines 4360, 4361. The Chen filing? Ah, that's what changed. Okay. So we're not requiring there be a prosecuting attorney for what we call a children in need of services filing. Correct. And that's what we had the other one earlier do. So this is just, again, a second place where it had to be modified. Move for that acceptance.
Is there a motion on the amendment?
Move.
Is there a second? There's a motion and a second. Any discussion on the amendment? Seeing none, the chair calls the question on the amendment. All those in favor say aye. Aye. All those opposed, no. The amendment carries. 2118.
Mr. Chairman, that'll be on page 127 at line 4393. This is again dealing with the issue of the prosecuting attorney. We're changing just prosecuting attorney to saying the person who filed the petition alleging the child is in need of services or committed a delinquent act. So that's where we opened it up earlier for the filing. So this recognizes that same purpose. Move for its acceptance.
Is there a motion on the amendment? Is there a second? There's a motion and a second on the amendment. Any discussion on the amendment? Seeing none, the chair calls the question on the amendment. All those in favor say aye. Aye. All those opposed, no. The amendment carries. 2119.
On page 129, Mr. Chairman, at line 4457, we have a change here again as to the prosecuting attorney. Again, following that same theme, we're having the person who filed the petition as opposed to just name only a prosecuting attorney.
Is there a motion on the amendment? Is there a second? There's a motion and a second. Any discussion on the amendment? Seeing none, the chair calls the question. All those in favor say aye. All those opposed, no. The amendment carries. 2120.
On page 131, Mr. Chairman, at lines 45, 52, this is again, I believe, dealing with the mandatory conference. Is that said? What was the change here, Ms. Travis? I'm sorry. Something different, yeah.
We added the sentence at line 3 on your amendment. If a complaint was not filed, this is the one that allows the amendment of
Okay, so we took, yeah, we replaced it at that 4552. Okay. So we're read how it's supposed to be for us, if you would, Ms. Travis.
The sentence reads, starting at 4550, the following consequences shall apply. And in paragraph 1, if any personal resident delinquency shall be filed within 30 days of the filing of the complaint, or within 30 days of the filing, release from pre-adjudication custody. If a complaint is not filed, the consent shall be filed within the statutory limitations
All right.
provided in Chapter 3 of Title 17.
And then we also have a change at 4557 at the very end. It says a petition alleging delinquency unless a continuance is granted as provided in code section 15-11-48 semicolon and continuing on. So we move for both of those amendments, Mr. Chairman.
All right. Is there a motion on the amendment? Is there a second? We have an amendment to the amendment. There's a misspelling.
Mr. Chairman,
Representative Welch.
Chairman, I have a motion. I call for a motion to amend line 3 where it says statute. Statute needs to say statute.
All right. Is there a second on the amendment to the amendment? There's a second on the amendment to the amendment. Any discussion on the amendment to the amendment? Seeing none, the chair calls the question. All those in favor say aye. Aye. All those opposed, no. We're now on the amendment as amended. Any discussion? Seeing none, the chair calls the question on the amendment as amended. All those in favor say aye. Aye. All those opposed, no. The amendment as amended carries. 2121.
This would be on page 132, Mr. Chairman, and 133. We're beginning at the line 4566. The change we have is adding into the line 4566 saying petition alleging delinquency unless a continuance is granted, which again falls through the previous potential exception by the court having a continuance. The second one is lines 4570 and 4571. We're inserting a new paragraph between those. This is new and it reads, a child who is released from detention but subject to conditions of release shall not be considered to be in detention for purposes of calculating time frames set forth in this article for the purpose of calculating time served. So the logic is they're not in detention, then that time should not be counted with their service time if there is a sentence imposed by the court of detention. Lines 4576 is a insertion here to add in, let's see, probation officers are taken out, and the probation intake officer and probation officers. So we put in probation and intake officers as well as probation officers of the juvenile court to have it cover both categories. The next one is at lines 4591, which is the very bottom. We are adding in a line about about representation of attorney. An alleged delinquent child may waive, let me read the part here. I think it was circumstances that set forth. But, all right, this again recognizes a child's liberty. You cannot remove the child and put him in detention unless there has been a representation by an attorney. And that follows through with upon the next line, upon a motion of an attorney for an alleged delinquent child together within written, trying to match up the lines here. That's right, very in the, prior to, I'm going to 4594, prior to the detention hearing, if any, the court shall appoint an attorney. We change that to say upon a motion by an attorney for an alleged delinquent child together with written. No. I'm sorry. Okay, that's where I got it. All right, let me match up with you. Is everybody thoroughly confused on that?
No.
Yeah. I am too. Go back over and let's explain it slowly, Mr. Travis.
Sure. Well, what 1511-475 does is it sort of sets up when does a child get representation by an attorney, and it also deals with the right to the attorney has to maybe get information within the court's purview. And the agreement among the parties was that if the child's liberty is not in jeopardy, then the child would not be needed to have representation. Of course, you could hire representation, but they wouldn't be entitled to appoint counsel. And for sure, the child would need that counsel at the point of an arraignment where an admission would be made. So when we were dealing with arraignment and the attorney and an admission, that's going to come up later in your 2126
Right.
amendment. So we took the language out of this code section and just made it clear that only when the child.
Yeah, reading the charges, arraignment does not require them to be counsel for representation of child unless there's going to be follow-up of the admission. Then there would be a need to have that before the admission is accepted by the court. Correct? Okay. That is the amendment.
All right. Is there a motion on the amendment? Question.
Get a motion
Chairman
first.
Weldon.
Chair, I have a motion to amend the amendment. On line 13, it looks after the words code section, it has the numbers 1-5. It looks like there's a space between the dash right there. If we could just take that out.
Why don't we just consider that a
So, that was brought to my attention by co-counsel over here. I am co-counsel.
you just accept that as a friendly.
I think so.
Okay. All right. With that, Cat, we haven't taken a motion on the underlying amendment, so why don't we do that? And the motion will include removing that space.
So moved.
Okay. Is there a second? There is a motion and a second on the amendment as revised. Any discussion on the amendment? Seeing none, the chair calls the question on the amendment. All those in favor say aye.
Aye.
All those opposed, no. The amendment carries. 2123 is next.
Yes, sir.
Okay.
2123, which is a very lengthy amendment. This is on pages 134 and 135, and it replaces 4644 line through 4675. Ms. Travis, why don't you address this one for us? Kick a punted.
This one does. I was curious about that space. I wanted to see if that was formulated and I was clear as space. But I'll get that in there. Oh, yes, this replaces all of what's in 1511-481, and what it does is it's an attempt to more closely mirror what's in code under 1710, 1710.1, whatever the Victim Rights Act is.
That's right.
With respect to adults and how the
Good point.
statements are used, and it brings in a lot of the language from the adult system into the child system in terms of mirroring, and so then
Correct.
everybody that's familiar with the courts can be on the same page when it
Yeah.
comes to making the
Yeah, those who served about 2-3 years ago, if I recall, we had a major bill come through rewriting what are the standards for victims' rights, and this is also bringing that same provisions into the juvenile court system. Move for acceptance.
Is there a motion on the amendment? Is there a second? There's a motion and a second. Any discussion on the amendment? Seeing none, the chair calls the question on the amendment. All those in favor say aye. All those opposed, no. The amendment carries. 2124.
The page 140, Mr. Chairman, at lines 4837, excuse me, 4837, and the change here is adding in, we're adding in the juvenile Governor's Office of Children and Families, which is another agency that is involved with this particular issues. Move that acceptance.
Is there a motion on the amendment? Is there a second? There's a motion and second on the amendment. Any discussion on the amendment? Seeing none, the chair calls the question on the amendment. All those in favor say aye. All those opposed, no. The amendment carries.
I might add just what we're doing in this whole area, which is important, is being sure that we get a proper accountability of information of all courts. That'll be the independent juvenile courts as well as those that are state authorized courts, juvenile courts, to be sure that we're getting good data in, and that will be used by the governor's office to help determine the what type of crimes are being committed, what's happening to these children, and all the reporting information we have coming down through the 13 items there. So it's a major step. I have a question over here.
Representative Welch.
Yes, sir, Mr. Chairman. I just wanted to let you know that a little before 3 o'clock I'll have to leave, but I wanted to let you know that I do support the endeavor that's been done on this bill, and so hopefully we'll get to it before I have to go.
We're going to push.
Next up, I've got, well, we're skipping a number. We have 2126 is next.
Yes, that's going to be at line page 144, 145, lines 506 through 5013, and that is replacing the section that has, as far as the B. Let me get back up here. Excuse me, I got two amendments there. That's right. We're actually adding in a new section B. I have to stop reading what we did here. This is again at the arraignment time, the child's liberty being in jeopardy. There will be, as we said earlier, the need for counsel if there's going to be a chance the child's liberty may be involved with that particular proceeding. So this is where we now recognize the court can appoint an attorney to represent an alleged delinquent child whose liberty is in jeopardy and who is an indigent person. Move for acceptance of that amendment.
Is there a motion on the amendment? Is there a second? There's a motion and a second. Any discussion on the amendment? Seeing none, the chair calls the question. All those in favor say aye. All those opposed, no. The amendment carries. 2140.
Yes, sir. On page 146.
Or 2127, sorry.
2127, page 146, lines 50, 46, and this again is recognizing the change we've made about the attorney situation, which we're going to get to with that bill, or I'm sorry, that section, which would be the new 15-18-6.1, which is the order of the rights of a prosecuting attorney. And that's just putting that provision into an area where it needs to be added. Next is on line 5050, and get my lines added here. This is just recognized, I believe, that there can be a refiling if there is a dismissal, as long as it's done within the statute of limitations. That's clarifying the language there. 5054 is also adding a new sentence at the end of that line which says, warranted, we add, upon a showing good cause and notice to all parties the court may grant an extension of time for filing a petition alleging delinquency. The court shall issue a written order reciting the facts justifying any extension. We would move for acceptance of that amendment.
Is there a motion on the amendment? Is there a second?
Second.
Motion and second on the amendment. Any discussion on the amendment? Seeing none, the chair calls the question. All those in favor say aye.
Aye.
All those opposed, no. The amendment carries. 2140.
It's page 150, Mr. Chairman, line 5208. Get to my lines number here. This is again dealing with the prosecuting attorney. It says we have it now saying, however, that a prosecuting attorney or entity prosecute. I'm not sure what an entity would be, but we're just leaving it as a, however, that a prosecuting attorney may offer any other evidence regarding alibi. We move for acceptance of that, Mr. Chairman.
Is there a motion on the amendment? Is there a second? There's a motion and a second. Any discussion on the amendment? Seeing none, the chair calls the question. All those in favor say aye.
Aye.
All those opposed, no. The amendment carries. 2128.
On page 151, beginning at lines 523 through 525, we are replacing with the following language, and we are this is recognizing the issues of discovery. Is that right, Ms. Travis?
It is, it more closely mirrors the sanctions in adult court with
Yeah.
respect to discovery and the ability to still get information under certain circumstances.
Right, and the court
Discovery violations.
and the court has oversight of it.
Yes, sir.
Move for acceptance.
Is there a motion? Is there a second?
Second.
There's a motion and a second on the amendment. Any discussion? Seeing none, the chair calls the question. All those in favor say aye.
Aye.
All those opposed, no. The amendment carries. 2129.
This is on page 152, Mr. Chairman, line 5248. It is also going to be recognizing, we say the prosecution in Superior Court, the district attorney shall cause a petition to be filed in the appropriate juvenile court for adjudication within 72 hours if a child is in detention or 30 days if a child is not in detention. This is again getting specific as to the time by which the district attorney or prosecuting attorney has to take the action to begin the proceeding. Move for acceptance.
Is there a motion on the amendment?
Move.
Is there a second? There's a motion and a second. Any discussion on the amendment? Seeing none, the chair calls the question. All those in favor say aye.
Aye.
All those opposed, no.
I get impatient.
The amendment carries. 2130.
Page 156, lines 5387, and I think we just clarified some. We're clarifying language here, Ms. Travis. That's right. That's not. Yeah, that's changed that word from an accusation. Okay. And the second one is at lines 5393. Again, the same thing, just changing that phrase, accusatory pleading, as being an indictment, special presentment, accusation. Move acceptance.
Is there a motion on the amendment? Is there a second? There's a motion and a second on the amendment. Any discussion? Seeing none, the chair calls the question. All those in favor say aye. All those opposed, no. The amendment carries. 2131.
We're replacing lines 5419 and 5420 with the following. We have here we continue with the in accordance. We've clarified Article 5 of Part 1 of Article 6 of Chapter 7 and Chapter 8 of Title 17. So we've carried it out further as far as the direction, what is involved in the next one, number 3, in accordance with the rules of evidence. Added that into the provision. Then we start back with number 4, which is now 3 in language understandable through the child, subject to delinquency, petition, and etc. The rest of that number, what would be now 4. Move for acceptance.
Is there a motion on the amendment? Is there a second? There's a motion and a second. Any discussion on the amendment? Seeing none, the chair calls the question. All those in favor say aye.
Aye.
All those opposed, no. The amendment carries. 2132.
On page 160, lines 55, 39, and this again recognizing the restitution. What is the change we had here, Ms. Travis? Following the procedures, yeah. We want, okay, I got it.
Added is in ordering the to make restitution, the court shall follow the procedure set forth in our restitution article in Title 17.
Right. So that is the added language there to clarify that. And then 5552.
Also mirrors the language that's in Title 17.
All right, for the same purpose, restitution. Move for acceptance, Mr. Chairman.
There a motion on the amendment? Is there a second? There's a motion and a second. Any discussion on the amendment? Seeing none, the chair calls the question. All those in favor say aye.
Aye.
All those opposed, no. The amendment carries. 2133.
Well, this would be at page 170, lines 58 and 98. We recognize the exceptions that are, this is dealing with what area, Ms. Travis? Restitution again, okay.
By the time you reach 21, you're still responsible.
That's right. So carries it past if they have a longer term for restitution. And move for acceptance.
Is there a motion on the amendment? Is there a second? There's a motion and a second on the amendment. Any discussion on the amendment? Seeing none, the chair calls the question. All those in favor say aye. Aye. All those opposed, no. The amendment carries. 2141 is next.
This is clarifying. We use the term on line, page 188, line 6517. We state the district attorney. We're changing that because it may not always be a district attorney. It could be a prosecuting attorney. So we just clarify the term.
Is there a motion on the amendment? Is there a second? There's a motion and a second. Any discussion on the amendment? Seeing none, the chair calls the question. All those in favor say aye.
Aye.
All those opposed, no. The amendment carries. 2134.
Be on page 190, lines 6577. And we change the sentencing and felony offenses, I think, on that section, yeah. That's right, criminal. And then on line 6579, which is changing again the prosecuting attorney, state or superior court judges, and it's added state court judges to the superior court judges.
Is there a motion on the amendment? Is there a second? There's a motion and a second. Any discussion on the amendment? Seeing none, the chair calls the question. All those in favor say aye. All those opposed, no. The amendment carries. 2135.
Page 192, Mr. Chairman, on line 6651. We're replacing that with the following language on number 4. Find my place. We're again recognizing prosecuting attorneys in this section, adding that into it as being law enforcement officers and prosecuting attorneys of the state, the United States, or any other jurisdiction. So it's just a cleanup. Move for acceptance.
Is there a motion on the amendment? Is there a second? There's a motion and a second on the amendment. Any discussion on the amendment? Seeing none, the chair calls the question. All those in favor say aye.
Aye.
All those opposed, no. The amendment carries. 2136.
This will be on the next page, page 193 at line 6703. And again, we're adding in the state court as being an additional court recognized in that area. And this is, again, clarifying. Move for acceptance.
Is there a motion on the amendment?
Move.
Is there a second?
Second.
There's a motion and a second. Any discussion on the amendment? Seeing none, the chair calls the question. All those in favor say aye.
Aye.
All those opposed, no. The amendment carries. 2137.
On page 203, Mr. Chairman, at lines 7050, we have placed in here the recognition that we have different type of felonies to be adjudicated in the juvenile justice, Department of Juvenile Justice, Class A, a designated felony act, or Class B, designated felony act, which are now, as noted, defined in 1511-2, and striking out and or convicted of a felony. So we just modified the language there to clarify the recognition of how this bill divides up the forms of felonies into a Class A, Class B within juvenile court. Move for acceptance.
Is there a motion on the amendment? Is there a second? There's a motion and a second. Any discussion on the amendment? Seeing none, the chair calls the question. All those in favor say aye.
Aye.
All those opposed, no. The amendment carries. 2138.
On page 215, line 7460, again, acknowledges the work of the Governor's Office of Children and Families in this area on the reporting, and we've added that particular office to the bill. Clarification. That's cleanup, Mr. Chairman. Move for acceptance.
Is there a motion on the amendment? Is there a second? There's motion and a second. Any discussion on the amendment? Seeing none, the chair calls the question. All those in favor say aye. All those opposed, no. The amendment carries. 2142.
In conclusion, wait for that, I'm sure. This is the provision that I addressed earlier when we were talking about the prosecuting attorney as a person for use in the juvenile courts. And what we've recognized here is, with resources being as they are from the state level as well as the county level, local governments, we want to have a qualified person as an attorney serving as a prosecuting attorney for the juvenile courts. I might stop and add, we did a survey through Eric Johns. Eric, you're here, I think, somewhere. Are you not? There you are. I had him do a inquiry of all the 48 juvenile courts we have in the state. All of them but 4 have someone who is a designated, I believe, employee either of the district attorney's office or a local, maybe state solicitor's office serving as a prosecuting attorney. The 4 that correct me if I'm wrong, Mr. Johns, but there are 4 of them that do what we call a contract prosecuting attorney in the state. One of them, I believe, is Mr. McDade's County, Douglas. But they're people who are employed through the county who service within the juvenile court, not under the directions of the juvenile judge, but under the court itself as a prosecuting attorney. Now, what we have here is a descending recognition that first we want to recognize there hopefully will be a district attorney representative of the office in the juvenile court, and in those kinds where that cannot be supplied due to resources, we can look to the Solicitor General's office of a state court in those counties should there be availability for service and working out with the county. If they're not able to do it through those 2, then it comes down to having, I'm read this, calls the district attorney determines that his or her office cannot provide representation for a state in a juvenile court of a county other than for an appeal. The district attorney shall notify in writing the chief judge of the Superior Court, the judge of judges of the juvenile court, and the chairperson of the county governing authority of such county of such determination. A copy of such notice shall be provided to the prosecuting attorney's counsel, state of Georgia, if the district attorney determines that his or her office may resume representation in juvenile court. He or she shall notify the chief judge of Superior Court, the judge or judges of the juvenile court of that fact. But upon receipt of this notice, the governing authority of the county may appoint 1 or more attorneys to represent the state in prosecuting delinquency cases in juvenile court, which would then be really a person either by contract or employment with the county. Such attorneys shall be compensated amount to be fixed by the governing authority of such counties. So we leave, say, much the same as we have with those 4 contracting courts today for that purpose. And this was suggested language, I believe, from the prosecuting attorney's counsel. Correct?
We have a couple of questions. Representative Welch.
Thank you, Mr. Chairman. Chairman, my question deals with line number 10. Allowing the district attorney to designate an assistant district attorneys, investigators, victims, witnesses, assistant personnel, and other employees to assist. Is that to mean that there will be an attorney practicing this licensed to practice law in the state of Georgia actually handling the case, but these may be individuals that will only assist in the prosecution of that? That's
correct. What we're looking at there is that the arrangement may be something worked out between the district attorney's office with the local governing authority as to what is needed for staffing to carry out prosecutions in the juvenile court. That may involve investigators and other personnel for that reason.
Chairman Weldon.
Thank you, Mr. Chairman. My question pertains to line 18 and 19. It says that if the workload is too heavy, then the district attorney shall notify the Superior Court judges and judges of juvenile court and the chairperson of the county governing authority. And there are counties where we have sole commissioners, and just as a point of clarification, would chairperson cover a sole commissioner, or do we need to put a provision?
I'm sure it would. That is a governing authority of either your commissioner or commissioners. The governing authority would be a single one or multiple person commission.
Okay, thanks, sir.
Representative Welch. He waves. All right. Is there a motion on the amendment? Is there a second? There's a motion and a second. Any further discussion on the amendment? Seeing none, the chair calls the question on the amendment. All those in favor say aye. Aye. All those opposed, no. The amendment carries. Any further amendments?
Mr. Chair, not amendments, but I would like to close out the
Chairman Willard.
thank you. A closing argument. But I'm just going to recognize all the numerous people who have had a great input with the preparation of this bill. Many of them are represented in the audience today who have worked with the committee, worked with the commission. We had the governor's commission on justice reform that took under weight the issues dealing with juvenile justice in our state this past year, have come up with a lot of good recommendations, although some of the things are not in need of being recognized by legislation. They are recognized as services being performed by numerous agencies of our state, and I think what we're going to see is a major turn of the way in which we have in the past handled juveniles in the state by hopefully saving lives that would otherwise continue down a road of ruin after they've been brought into a juvenile situation, specifically of delinquency. We know that we've unfortunately been taking too many of them and putting them in detention facilities, secure facilities that may not have been always necessary. There are those that do need to be in a secure, very much a secure facility, and they will continue that way. But we hope that what we're making is major strides in finding better practices by setting up community services, community facilities to take the children and who are not doing major crimes, what we call the Class A felonies and some Class Bs, but trying to find ways in the community to work with that child and help that child and the families to not have the child continue in delinquency. We have a 65% recidivism rate in the state, which is just totally unacceptable. And that means we're having children 3 years coming back, experiencing again some form of judicial system. So I have great hope with all the parties who have been involved with this. We will see, just as we have with our adult justice system, some changes that will be very beneficial to our state. I'd like to close by thanking also the prosecuting attorneys who have had a hand in the preparation of a number of these amendments to get clarification. We also had a number of departments here. I don't want to try to start mentioning ones because I'll miss somebody, but it's been a real joy to have a part in it for the last, now 3 or 4 years. I know it started out as a program for let's do a rewrite of our code to make it read better, and it has blossomed and mushroomed from there to what we have today is this bill and all the various programs the governor's going to be implementing. So the governor's very committed. He's put $6 million in the appropriations this year to start these programs, and what you'll see is the money being used in areas where we know a lot of children by percentages have been placed in state detention. And why? Because we haven't given those local communities and the courts really the services available to make the changes they want to make. So I think you'll see funds coming in those areas. It'll gradually grow. The governor's committed to saying that where we see these savings happening over the next number of years, a lot of that money is going to go back into the programs to continue the growth of those programs to benefit all the states. So I think we've got a good program underway. We've got a good bill here, and I'm thankful again for everyone's assistance. That concludes my comments, Mr. Chairman.
Chairman Willard has the last word. We are now on the underlying proposition, and that is to give a due pass recommendation to House Bill 242, the Juvenile Code Rewrite, LC 295444, as amended by the committee.
So, yeah, pass substitute.
All right.
Committee substitute. As
By committee substitute, as amended, not as amended.
No, just get it
Okay,
substitute.
by committee. All right.
With the amendment.
We're now on the underlying proposition. That is to give a due pass recommendation to the committee substitute to House Bill 242. All those in favor say aye.
Aye.
All those opposed, no. The bill moves forward to the Rules Committee with a due pass recommendation.
Thank you. I'll take it
Mr.
back
Chairman.
over. Mr. Chairman, let me have two announcements. We're going to have two subcommittees meeting this afternoon. The Powell Subcommittee will meet upon adjournment in this room. The bill we're having is the what?
You have elderly abuse.
Elderly abuse, yeah. HB 78, I believe it is.
Yes, sir.
Is that the only one?
No, sir. There's some others. We also have Representative Dutton. No, that's. Sorry, I wasn't prepared for everything.
Well, there
Representative Hamilton's bill, HB 139.
HB 139. And
Representative Knight's HB 291.
HB 291.
And I believe there's
Okay.
at least one other one.
They were published. I just wanted to try to mention them. We also have Jacob Subcommittee meeting here upon adjournment of the Powell Subcommittee, or at 4 o'clock,
In 403.
whichever, in 403, excuse me. That's going to be across in the Coverdale. No, it's here in the Capitol, sorry. Here in the Capitol, room 403 upstairs.
It's in 403.
If there's nothing further to be brought before the committee this afternoon, we stand adjourned. Thank you.